Your patents suck because you're not willing to appeal the examiner's decisions. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please do me a favor and like, follow, and share. Look, when you're trying to get a patent, initially at least, your fate is basically in the hands of one person, maybe that person and their supervisor, but that person is the patent examiner. Patent examiners have heavy workloads, and they have varying degrees of, I'll say, competence and enthusiasm for their jobs. I've had some who were phenomenal, who I thought should be lawyers. I've had some who I thought maybe should look for another line of work. Okay, and part of the issue is that they are applying the law, but they are not lawyers. They're applying the law the way the Patent Office interprets the law and tells them to apply it, and sometimes they get that quite wrong. And they have varying degrees of technical competence as well. And so, you may very well, and it is not infrequently the case, that you will get stuck at some point and you will get an examiner who will not budge and allow a claim that you think is patentable. And if that happens, your recourse is to file an appeal with the Patent Trials and Appeals Board, called the PTAB. Now, I'm not going to lie to you, they're not cheap. The fees to the Patent Office alone, depending on if you're a small entity or a large entity, are anywhere from like $1,200 to $3,200 for the notice of appeal and forwarding the brief to the board. But, it's like anything in the patent world. You should be doing a cost-benefit analysis to see what it's worth to you to fight for it. But, the appeals are decided by a panel of 3 administrative law judges who have expertise in patent law, and it is not uncommon for examiners to get reversed. It's not at all, in my experience and the experience of those I have talked to about it, it's not at all a rubber stamping of the examiner's decisions. So you may very well get relief. But at the end of the day, you can't let everything sit in the hands of one person. Sometimes you have to get the matter out of the hands of that examiner and into the hands of the appeals board if you actually want to get those tough to get claims. It's easy to get the narrow ones allowed, but the ones that are worth something you're going to have to fight for, and that often includes filing an appeal. And I've had clients who just as a matter of course refused to file appeals, and I think their portfolios would have been stronger had they at least on occasion been willing to do that, but they weren't. So anyway, I hope that helps to keep you out of trouble, and I hope to see you here soon.